Welcome everybody to Divorce Unplugged for episode 12. My name is Dane Frew, and as always I am joined by Geoff Ebbett. Geoff, how are you?
I'm really well, and it's a pleasure to be here to talk all things divorce and related.
Always a pleasure. We're going to go through some changes that we may see moving forward to the Family Law Act. So I will ask you some questions in relation to these changes, and we'll go through them. And as always, at the end, we will touch on a health topic, which I know excites the listeners and the viewers. So can you give us an outline, Geoff, as to what's happening?
All right, so let's look at, there's been a couple of fairly significant changes to the Family Law Act. There's been a number of changes over decades, but there was some changes that actually came in this year in relation to how children's care decisions are managed, I'll call it that, were codified in more significant detail, and a new different framework was brought in. But we're not really talking about that today because we're looking into the crystal ball of the future, and there's been a new bill put forward to Parliament which looks at some fairly significant changes to the Family Law Act, which will probably come in 2025. But it's probably worth just mentioning now because it may have an impact on people moving forward.
Yep, so what's a good starting point?
Well, I think the first starting point of the bill it talks about is this funny thing about codifying, which is a fancy word for basically saying we want to put in legislation how we go about determining, for example, a property settlement.
All right, so how will this occur?
Well, weirdly, if you're a mum and dad and you want to look at the Family Law Act and determine how you divide your assets, it doesn't give you a very good, helpful guideline. What it does talk about is things like contributions before the relationship and what financial and non-financial contributions that parties make during the relationship, and what are the parties' future needs, and weighing all of these things into a big grab bag. How do you divide things up? But what the new bill is trying to do is actually set that down in more plain English about how parties will go about determining what is a fair settlement between them.
Yep, so can you explain in practical terms what it means?
Well, in practical terms, it'll mean that it will set out, for example, that a major consideration will be if one party comes in with significantly more assets than the other party, or if they have the care of children on a significant basis after separation, then that will be a factor that means that one party should receive a greater share of the assets in their favour.
Yep, so what else do we see coming up?
Well, that's a good point. So we've also got things in relation to children and pets, interestingly.
Pets?
Pets. So in the explanatory bill I was reading, it talked about that obviously the family pet can be very important, and who actually gets to retain that pet is sometimes disputed in court. I've seen a couple of examples in my career about this, but not too many, thankfully. But what it's going to do is it sets out in some detail how a court should consider who will retain the family pet.
Right. Okay. So moving away from pets, an unfortunate topic, where does family violence sit in with the changes?
Family violence is a pretty significant part of the changes looking for 2025, and they're trying to expand how a court looks at the issue of family violence in terms of the context of a property settlement. So to explain this, you've got to sort of jump back in history a little bit. There's not much really in the Family Law Act that talks about family violence as a factor about whether the property division should change from a 50-50 or something else. The only thing that happened was there was a significant case called Kennan, which talks about one section which basically looked at if there was family violence which impacts on one party's future needs, i.e. they've suffered such trauma, physical or psychological, that might impact their future earning capacity, that's something that the court needs to take into account. But apart from that, if there was quite an abusive relationship but there is no provable psychological damage, for example, then it has zero impact on whether that person who undertook all of that violence should receive an equal amount as to their spouse.
And is that always how it's been done?
That's how it's been done up until now. So this new act coming in next year is looking at trying to deal with those things and actually specifically saying that the court must take into account a number of factors. And um, how that impacted on the economic earnings of the parties during the relationship. Talks about how it might impact on things like spousal maintenance going forward between the parties, and it even extends to an unusual concept that is not really spoken about too much, but it's called dowry abuse.
Can you explain what dowry abuse is?
Yeah, so in some cultures, particularly Middle Eastern cultures, we see the concept of a dowry, and that is an economic amount, which can be described as a financial sum or some assets, which is paid by the bride's family to the groom. Some of that actually is sometimes just a promise to give if it's requested, but sometimes it's physically handed over at the time of the marriage. So economic abuse in a dowry might be an example of the groom or the spouse then during the marriage demanding a greater dowry from the bride's parents, or he will cause to the bride physical harm to the bride unless he receives a greater share of assets from the parents. So
right,
yes, so Australia is a very broad and multicultural country, and whilst personally, I've never had a case of dowry abuse. Certainly, it's something that it's coming up more and more, and the court needs to reflect the changing demographics of Australia in dealing with it.
Right. What about any technical updates?
So technical updates. Well, we've got a couple. We're dealing with the things about disclosure. Now, disclosure is a principle in the Family Law Act that basically talks about that parties have to share information so they can make a fair decision about what property they have, and then how it's best divided. So if I, for example, have two bank accounts and they've got $100,000 in them, but I refuse to hand over any details of those accounts, it makes it very hard to negotiate a fair property settlement. So the changes to the legislation will enshrine in more detail the obligations of the parties to provide that disclosure, and provide some downside or impact or penalties for parties who refuse to comply with that regime.
So can you explain the practical impacts?
Well, I think from a practical point of view, what will happen is that if a party refuses to be cooperative in the issue of disclosure, that the court will take a negative inference. It will be enshrined that they have to take a negative inference and basically make assumptions and then adverse to that person, and then provide an outcome that takes into account that negative assumption.
Yep, okay. So what about sensitive information relating to health and or violence?
Well, one of the curiosities and unfortunate side effects of a property settlement is that the health and future needs of the parties can come into being, and one of those things might be sensitive medical information that may have arisen after separation, but one party doesn't want to disclose to the other. So if you've been separated for a number of years before deciding to separate property, and you don't want to disclose that you've got a cancer to the other party or some significant health issue, then you shouldn't have to. Why should you? And basically, the new legislation is proposing a system by which that information can be made available to the court, but not necessarily to the other party, which will assist in preserving some confidentiality and dignity for both parties.
Yep. So do you, in your opinion, see any downsides to these changes?
Not really. Is it going to make it more complex to commence proceedings? Probably, because you're going to have to do more steps before you sort of kick off any court proceedings to resolve these matters. But that's one of the sort of potential downsides, is every time you add pieces of legislation to or parts to legislation, you're going to have the downside that you've got to have more understanding of it, and by having more understanding, there's going to be more steps, and if there's more steps, there's going to be greater expense initially before people can get stuck in.
So what about divorce applications? Are there any likely changes to happen in that area?
Interesting, it looks like there is. So we have divorce applications currently. So you cast your mind back a few years, essentially to proceed with a divorce application, you had to queue up in about groups of 15 and go in front of a court registrar and have your divorce heard. When COVID came, we started having the process of electronic hearings, and then a number of hearings were dealt with what they call on the papers or in-house. So we've had a changing system so that the only in-person hearings, which are now done electronically, are ones where there are children under the age of 18 and it's an individual application. So the change you mentioned is that they're looking at if there's enough information in the paperwork to do with the care, well-being of the children, i.e. that their circumstances are adequately disclosed and they're being looked after, then the court will still deal with individual applications with children on the papers unless they otherwise want more information, and then they'll essentially call you in to appear.
Yeah, okay. So when are we likely to see these changes?
Hard to tell. There's nothing. The legislative process is still in train, and we haven't quite got through the court, both houses of Parliament yet about it. So there'll inevitably be some tweaks to this. But if you look at historical precedents in terms of where this matter is up to now, I would say probably in the second half of next year.
Yep. All right. So that's basically it for the upcoming changes. Do these changes happen often?
Well, we've seen a raft of them in the last 5 years, it seems. So the Family Law Act was pretty steady for quite a long time, and then last year we saw significant children's changes this year, and now we're seeing another update again. So I would hope that Parliament and the courts will give it all time to settle down and see how it all progresses before we see more changes coming through from there.
Yep. All right. That's that bit done and dusted. Now on to our health topic. I'm going to leave that up. What are we talking about today, Geoff?
Today it's a wisdom. We're on the wisdom side of things. Rather than we've done some physical health recently, we've worked on our breathing, we've worked on a couple of different things, getting unbogged. But today's again a mental topic, and I'm talking about. There's a famous blog. So a blog is, for those who remember, were very popular before podcasting came along to some extent. But a blog is a regular article published, or almost like an email newsletter, which gives information to people. And there's a guru of blogs called Seth Godin, who's been out in the world for now, and he's in his late 60s, early 70s, and he's been publishing a blog for nearly 20 years, providing wisdom about human behaviour and marketing generally to the point of understanding human behaviour in a positive manner.
All right. So what are some insights that we can draw on?
Well, if you go and look up Seth Godin, that's Godin. There's a couple of Seth Rogen. Don't get him confused with Seth Rogen. There are more than one.
Different insights from Seth Rogen.
You probably will, but Seth Godin will. If you go and he writes in a really interesting style, and if you about topics, and I'll give you just a couple of examples. If the listeners have basically 2 minutes, I'll give you 3 examples of short form blogs that he will write that helps you probably understand human behaviour. So I'll jump into one from the 12th of September, way back in 2022, and that was basically trying to understand that if you're wanting to produce some work, or being a creative, asking yourself the question, who cares? And he basically says this: who cares? If no one cares, that really happens. So he then says, if someone cares, that happens all the time, and it's the heart of all the work that you do. And he says, everyone cares, and he says, that almost is never the case. So he says someone is enough. In fact, someone is the entire point. So if you're doing something, you want to do something positive for the world, if someone cares, that's the whole point. So that's his blog. So that's the first one. Another one,
short and sharp as that.
Short and sharp. Some are a little bit longer, but there are a number of ones which are only, because he publishes every day, some of them are only a couple of paragraphs long. He talks about your autobiography, for example. He says even the longest biography is only 66 hours on audio. That means that the author has nearly need to leave out almost everything. So he says, we write our own autobiography each day by deciding what to focus on, what to rehash, and what to worry about. The same life story can be told in many ways, and the way we tell it changes who we are and who we become. Who is editing your version?
Good one. You got one more for us?
I'll throw one more in.
Yeah, chuck one more.
All right, we will.
You're on a roll.
I am. Thank you, Dane. So this one is a blog called The Last Thing and the First Thing. So he says, the new ritual, even more than checking the windows and doors before bed, is to check the incoming. Doom scroll a bit, check Slack and email, and make sure there are no loose ends. And then the ritual continues. First thing in the morning as we check the overnights to make sure everything is still okay. What if, instead, just for a week, the last thing we did was make a list of exciting opportunities for the future? And if the first thing after waking up was doing some morning pages and jotting down what we're looking forward to? There's plenty of time to check the windows and doors during the rest of the day.
Yeah, I like it. That's good. So we'll link that blog in the show notes, so people can jump on and have a look if they've been inspired by those three blogs that you've just read out there, and they can go through and in their own time read through them.
Absolutely. So instead of doom scrolling, you might want to read one every morning or when you first get up, or you might want to read it before you go to sleep. It's something more positive than necessarily watching the goats or cats.
No, I like it. All right. Well, that's us done for episode 12 on Divorce Unplugged. Thanks for joining us. Geoff, thank you again for sharing your thoughts and your thoughts on wisdom. Thanks to our new friend Seth.
Yes, and thanks for having me. And hopefully when those changes to the Family Law Act happen, we'll be happy to give you an update and some more precise and concise information from there.
All right. Thank you, everyone. We will see you next time on Divorce Unplugged.